Welcome to the Fixer Podcast.
Hello and welcome to The Fixer with experienced attorney and author John Tatoian. Thanks for joining us today. I am your host, Kevin Rosenquist, and today's episode is Fighting Back, Protecting Consumer Rights in the Face of Corporate Power. John, so great to see you again.
Thanks. Nice to be here. Good to see you.
So the concept of David versus Goliath often applies when consumers face large corporations. What rights do consumers have that can help level the playing field in these disputes?
I would not recommend for a consumer to take on a large conglomerate on their own. That would be a little bit crazy. Hire a law firm is the thing that I would do, and have them assert your rights. That's what I would recommend, because a lot of times I get calls from people that are up against insurance companies, large banks, large multi-billion or million-dollar conglomerates, and those conglomerates have an FU attitude. Students go pound sand, basically, or to go take a long walk off a short pier. And that's the attitude they have. And I actually was just talking with someone who is up against that with a bank, and the conglomerates, their strategy is very, very basic. The conglomerates will break the rules, whatever rule the regulations are in place, and the regulators will come in, whether it's the bank regulators, the DOJ, or whatever agency regulates them, and they'll fine them, and they'll just pay the fine, and they'll chop it off as a cost of doing business. And the amount that they pay is obviously less than the profit that they're making, so they always make a profit. Remember, Standard Chartered Bank, but it kind of sticks up my head. They were laundering money for Iran and had to pay some exorbitant, like $200 or $300 million fine, what it was. But I just wrote a check out, made that fine, and that was it. So they will violate, if there are questions, they will violate consumer rights indiscriminately, and they'll tell you that, what are you going to do about it? And my advice is call a law firm. But that's the basic business model in psychology of these large, as you call them, Goliaths and Goliaths.
What are some of the most common situations where consumers might feel overpowered by corporations?
I think the two major types of conglomerates or Goliaths where people really feel extremely overpowered or frustrated, in my experience, I think we start banks, financial institutions, and insurance companies. And it's kind of a double-edged sword, because the insurance companies and the banks, depending on the amount of money that you're talking about is very low, they'll throw you some money with nuisance money. But if it's very high, they tend to get a little bit nervous. And the reason why is because when you haul them into court, a bank or an insurance company, jurors, the average person that tries the jury, hate insurance companies and they hate banks. So that's on the consumer side. And I mean, I know that the jury is instructed to follow the law, but there's always that emotional side of them that
sure
is going to say, well, I've had personal experience with banks and financial institutions and insurance companies and not being paid and being denied benefits, etc. So there's always that emotional part of a juror that influences their decision-making process. You really can't get really a handle on. So
when is it appropriate for a consumer to take legal action against a corporation?
I always, when I'm called or contacted by a consumer, my protocol is to ask them to explain to them that I try to resolve the situation or the dispute amicably outside of court. And I would usually charge a flat fee or a contingent fee. So I would try to attempt to contact the company and work it out in a reasonable fashion, with the assumption or the implied assumption that no one wants to go to court because it's unpredictable, it's expensive, and it's ill-debated, and it's frustrating. So if they tell me to go pound sand, and I come back to the client when they say, I'm going to go pound sand, so you have goods and letting it drop, not doing anything, or hauling them into court, which one explains what the costs. They do a cost-benefit analysis. So it's we'll see if the benefit of those costs, given the risk factor, with respect to the law and the facts of the case. If that benefit outweighs the cost of a burden, then go to court. If it doesn't, and obviously it doesn't take a rocket scientist to figure out if you're owed $10,000, it's going to cost you $15,000. You're gonna let it ride. But if you're owed $50,000, it's going to cost you $10,000. You have to weigh the law and the facts to assign a risk factor, how likely it is that we're going to get that $50,000. There's a 50-50 chance you're going to get it. It's really the ultimate decision. It's up to the client. I can only explain what the risks are and what the benefits are, what the costs are, what the benefit might be. The weaknesses, unless the client decides which way to go.
What steps should someone take to build a strong case in these situations?
I think the best thing that a potential client can do is to keep a log. It's called, in evidence, it's called task recollection report. So keep a log of conversations that you might have with your adversary, your opponent, company you're going up against. Record conversations with the caveat, do not record conversations without the consent of the other party. The other thing is to document, keep all the documentation, email chains. We don't use letters anymore. It's gone. It's all email chains. Email chain logs of conversations or events that happen. And if you can, record the conversation. So it's build up a panoply of documentary evidence that will support your case. Doesn't always work out, but because they don't know the rules of evidence or what you should do as far as they don't know that they're going to go into litigation. But once you know you're going to go into litigation, you're going to litigate, and that there's a dispute that might go to court, possibility. Anticipation of litigation. We should follow those rules of collecting and assembling and evidence. That's always my advice.
Okay. And in your experience, what legal protections are most underutilized by consumers when they face unfair treatment by companies or creditors?
There's a whole conglomeration of federal laws and state laws that protect consumers. It's a pretty broad question, but if you retain a law firm to handle your dispute, depending on the facts of dispute or the situation, there are, in debt collection, there is the Fair Debt Collection Practices Act, and that's 15 U.S.C. 1692, that protects consumers from abusive, harassing, misleading practices by debt collectors. There's Regulation Z, which is probably known as Truth of Lending, which obligates certain companies that are giving loans out to consumers to follow certain mandated disclosures. There's the TCPA, called the Telephone Consumer Protection Act, where you get local callers calling up people about what you can get. This drives them crazy, trying to get on the no-call list or your phone up. But there actually are actions, right action under that particular statute. And it calls for, if each violation is $500, and if the judge finds that the violation is willful, then it's a triple it. And they can also, on all of these statutes that I've articulated, what the legislature has done to protect consumers even more is to put in the statute a fee shifting provision, which means that in general we follow what's called the American rule, which is each party pays their own legal fees. So if I'm suing you, I hire a lawyer $5,000, so you don't pay my lawyer's fees, I pay my lawyer's fees, except in two circumstances where there's a statute which states that the prevailing party will win against you, you pay my legal fees. And that's commonly done with consumer statutes. It's commonly done in the Fair Debt Collection Practices Act and various state unfair trade practices act, Regulation Z, the Fair Debt Collection Practices Act, the PCPA. Attorney's fees are allowed to the prevailing party. In other words, if the consumer prevails, the opposing party pays their attorney's fees, which is a pretty good incentive and a pretty good thing for consumers to be aware of.
Yeah, that's a big one. What role do class action lawsuits play in defending consumer rights, and how can individuals benefit from joining or starting one?
I remember class action lawsuit that I did against a company, a debt collection company, and what they did was they prosecuted or violated one of the provisions, basic provision of the Fair Debt Collection Practices Act, and it's a very, very small amount of money. So it wouldn't have made any sense really for one person to sue the company. So we got together a whole conglomeration of people that were being violated, whose rights are being violated in the same manner as the initial plaintiff. And that increases the damages. It increases the power that you have, the step or the hurdle that you have to, as a consumer plaintiff, that you have to get over is you have to what's called certifying the class. Under the federal rules, I think it's Rule 23, there has to be, to certify a class, there has to be numerosity. So there's a large number of people that are, to be like just people. It's to be like, I mean, it's up to the judge, but 20, 30 people. So that's the numerosity requirement. The second requirement is that the class has to be, the judge has determined that it's the class adequately represented. The other thing is that a claim, there has to be a common questions of want back amongst each of the members of the class. They can't have different claims. They'll have to pretty much have the same claims. There's to be a commonality amongst that they have against the opposing party. And then the class is sort of molded at the end. The order in which everyone is paid is the plaintiff. The plaintiff, which represents the class, gets pretty much paid first, usually more money than the attorneys get paid. And then whatever's left in the pot is pretty much divided up on an equal pro rata basis amongst the other members of the class. So it can be a pretty powerful tool, but there has to be those four requirements: and numerosity, and common questions of want back, typicality, claims, and presentation. You meet those four requirements, the judge will certify the class, and you give a lot more bang for your buck.
What advice would you give to someone who feels overwhelmed by debt collection agencies or creditors, especially if they feel like their rights have been violated?
Well, that's an easy question, and it's one of the easier questions to ask. To call a lawyer. Do not. It's like saying, asking, what advice would you give someone who is having extreme pain in their right upper quadrant? Do not try and operate or solve your problem yourself to operate on yourself. Call a doctor or urgent care. Retain a lawyer, go to a law firm. Don't try and do it on your own. It's not what I recommend.
What typically happens when people try to do it on their own, in your experience?
It varies from people that are bringing frivolous lawsuits, in which case they can get sanctioned by a judge, and that's never a good thing. To people that are doing it themselves, pro se, they typically don't know the law, or they might know the law, and it really mostly trips them up with the evidentiary rules and the procedural rules. So the procedural, might know the law and might be completely 100% right, have the law and facts in your favor, but you have to be able to navigate the procedural machinations to bring your case properly when they try or fact, or it's a judge or a jury. And to need to know not only the procedure, but the evidentiary rules, because the evidence proves the facts of your case, and the facts of your case are what the trier of fact uses to conclude whether or not your rights have been violated. So the evidence establishes the facts, and the fact establishes from the facts you can draw a conclusion of law, your legal conclusion. And that's pretty much the way it works.
Okay. So call a lawyer, call someone who knows.
Call somebody that knows the evidentiary rules very well, and most importantly, the procedural mechanisms, because judges have a lot of cases, they have a lot of work, they don't have a lot of patience. If they see somebody that's pro se, they kind of they do things the wrong way, and it's all gets discombobulated. They get impatient, and an impatient judge tends to get frustrated, and that's not the judge that you. It's not what you want. You don't want a frustrated, impatient judge. They're impatient enough, but call a lawyer.
Don't poke the bear. Well, I would say that's good advice. Well, thank you for tuning in to The Fixer with experienced attorney and author John Tatoian. To connect with John, visit johntatoianlaw.com or give his firm a buzz at 860-490-4138. And don't forget to like and subscribe and leave us a review in the comments. John, thanks so much for being here. Great to see you again.
Thanks.
Thanks for watching. Be sure to hit that like and subscribe button and leave us a review in the comments.